Free speech jurisprudence has rested on shaky ground for decades in this country. Looking back at cases like Hill versus Colorado, Austin v. Reagan National Advertising of Austin, and Dobbs v. Jackson Women's Health has left a confusing and contrary morass of precedent, most, if not all of it, contradicting the Constitution of the United States. With the recent case, Coalition Life versus City of Carbondale, Illinois, the court had the opportunity to set their record straight once and for all. Instead, the court whiffed and declined to even hear the case. Now, we'll look at this next on the Constitution Study.
Love the neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution, teach the rising generation to be free. You talk about freedom of speech and these basic freedoms, and we realize that in this country, they're no longer based in the Constitution, but the decision of courts, the superseding of precedent over the actual law. Now, in this case, Coalition Life, there's an interesting situation because the court decided not to hear the case. However, Justice Thomas, he posted a dissent, which teaches us a lot about the jurisprudence involved in this case. Now, I'll talk more about the case, where you can find the links and all that stuff at the end of the episode. For now, let's dive into this case of Coalition Life versus City of Carbondale. As always, the best place to start is at the beginning. Petitioner Coalition Life is a Missouri nonprofit that organizes sidewalk counselors to counsel, educate, pray, display signs, and distribute literature outside abortion clinics. Their goal is to engage in one-on-one conversation in a calm, intimate manner, as they find that approach most effective. The organization prohibits its counselors from engaging in intimidating or threatening behavior. Sounds like a simple example of exercising the right to peaceably assemble to me. But if it were that simple, well, I wouldn't be recording this episode. Until the passage of Ordinance Number 2023-03, Coalition Life counselors engaged in sidewalk counseling outside abortion facilities in Carbondale. But the new ordinance severely hindered their ability to do so. The newly enacted 100-foot buffer zone meant that Coalition Life counselors were forced to stand far away from those with whom they wished to speak. In some cases, sidewalk counselors had nowhere to stand but in the middle of busy roads, rendering intimate counseling activities effectively impossible. Imagine being told that you cannot come within 100 feet of a location simply because you disagree with its stated purpose and wish to discuss the facts with their customers. Again, we aren't talking about intimidating behavior. That was prohibited by Coalition Life. And if someone prevented someone from entering said business, I believe that would be criminal as well. But according to the complaint, none of that ever happened with members of Coalition Life. Coalition Life sued the city of Carbondale, alleging, among other things, that the ordinance violates the First Amendment. Problem number one for Coalition Life is the ordinance cannot violate the First Amendment because it wasn't passed by Congress. Remember, the First Amendment reads, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech. Since Congress didn't make this law, it cannot violate the First Amendment. But that doesn't mean the act was unconstitutional. All persons may speak, write, and publish freely, being responsible for the abuse of that liberty. Now, since this is a violation of the state constitution, it's not within the jurisdiction of the federal judiciary. However, that isn't the only violation of the United States Constitution. The 14th Amendment reads, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law. Since Carbondale made and enforced an ordinance that abridged the right of freedom of speech and deprived people of their liberty to engage in conversation with others without due process of law, it is a clear violation of the 14th Amendment. The complaint may have mentioned other violations, but it appears only the First Amendment question was brought to the court. Needless to say, the city of Carbondale wanted this suit to go away. When Carbondale moved to dismiss the suit under Hill, Coalition Life responded that over the years, Hill has been eroded, but it nevertheless conceded that its claims were foreclosed insofar as Hill remains good law. When the city moved to dismiss the suit, they pointed to a Supreme Court decision known as Hill versus Colorado. This leads to the second problem with the Coalition Life case: the belief that the previous decision of a court is law. It is not. Hill is precedent, showing how the court had previously decided a similar case. The importance of this will become evident as we get into the dissent. The district court dismissed the suit on the grounds that Hill and binding Seventh Court precedent controlled. The Seventh Circuit affirmed on the same grounds, acknowledging the plaintiff's assertion that Carbondale's buffer zone was modeled after and nearly identical to the one upheld in Hill. Because Hill was the exclusive basis for both decisions below, this case clearly and cleanly presents the question of Hill's viability. So this whole case was decided because it matched the case Hill versus Colorado. But was that case rightly decided? So the history of this particular violation of the people's rights goes back to the Hill case from the year 2000. In Hill v. Colorado, this court upheld a state law restricting peaceful speech within 100 feet of abortion clinics. Now, what made this law restricting speech so special? Why did the Hill court uphold the law? According to Justice Thomas, Hill's abortion exceptionalism turned the First Amendment upside down. As Hill's author once explained, the First Amendment reflects a profound national commitment to the principle that the debate on public issues should be uninhibited, robust, and wide open. That principle applies with perhaps its greatest force to speech that society finds offensive or disagreeable. Yet Hill manipulated this court's First Amendment jurisprudence precisely to disfavor opponents of abortion and the right to persuade women contemplating abortion that what they were doing is wrong. Justice Thomas makes a couple of very important points. The court has used abortion as an excuse to ignore not only the First Amendment, but their oaths and duties as justices. As the author of the Hill opinion, I believe Justice Stevens wrote, the First Amendment reflects a profound national commitment to debate on public issues. Yet the Hill court, along with the district and circuit courts in this case, ignored that commitment, apparently for one reason and one reason only: to stifle debate about abortion. To be sure, this court has not uttered the phrase, "we overrule Hill." For that reason, some lower courts have felt compelled to uphold Hill-like buffer zones around abortion clinics. This case is another prime example of that trend, and one can hardly blame lower courts for misunderstanding. When we have created confusion, we are responsible for resolving that confusion, and we should have done it so here. See, in 2000, the state of Colorado passed a law intentionally restricting speech. While this may seem to be an obvious constitutional violation, the Hill court got it wrong. It was clear at the time that Hill's reasoning contradicted more than a half-century of well-established First Amendment principles. A number of us have since described the decision as an absurd, defunct, erroneous, and long discredited aberration from the rest of our First Amendment jurisprudence. However, it wasn't just the Hill court that got the First Amendment wrong, but Justice Thomas. We have long stopped applying Hill, and a majority of this court recently acknowledged that Hill distorted our First Amendment doctrine. It seems the court long ago saw a problem with their Hill precedent, specifically distorting their First Amendment doctrine. But did you notice that? Justice Thomas didn't say that Hill distorted the First Amendment, but the court's doctrines did. That arrogance did not end there. Following our repudiation in Dobbs, I do not see what is left of Hill, yet lower courts continue to feel bound by it. The court today declines an invitation to set the record straight on Hill's defunct status. I respectfully dissent. Don't get me wrong, I agree with Justice Thomas that the court should have taken the case, but not for the same reason. See, he appears to want to establish a new precedent, while I want to restore the Constitution to its rightful place as the supreme law of the land. When Coalition Life petitioned for their writ of certiorari, the court declined to hear the case. Justice Alito said he would grant petition, but Justice Thomas is the only one who issued a dissent. Let's look at Thomas's view on Hill in a little more detail. Hill involved a 1993 Colorado statute which established buffer zones around abortion clinics. The law made it a crime for any person within 100 feet of any healthcare facility entrance to knowingly approach within 8 feet of another person without that person's consent for the purpose of passing a leaflet or handbill to, displaying a sign to, or engaging in oral protest, education, or counseling with such other person. Put another way, Colorado's law, still in effect today, prohibits unconsented sidewalk counseling within 100 feet of abortion clinics. Colorado enacted what is commonly called a buffer zone law. Actually, this is a double buffer, since within a 100-foot buffer of a healthcare facility entrance, you are not allowed within an 8-foot buffer of someone else, but only if you wish to exchange information. Shortly after the law's enactment, a group of self-described sidewalk counselors who sought to peaceably educate and counsel passerby about abortion and abortion alternative challenged the law under the First Amendment. This court upheld the law as a content-neutral time, place, and manner restriction. This is one of those free speech violations that the courts have adopted. As I pointed out, the Constitution of Colorado protects freedom of speech. Yes, you can be held accountable for the abuse of that right, but how is approaching someone to engage in that right abuse? The real question that should be asked is, who has the responsibility to stop someone's speech? Imagine if freedom of speech everywhere was treated the same way Colorado treats it around the healthcare facilities. Excuse me, is it okay if I wave and say hello to you? Do I have your permission to return this set of keys you just dropped? I'm sorry, is it okay if I drive past you with a sign on my truck? But the court claimed that the state could abridge the freedom of speech as long as it wasn't based on the content of that speech. Hill's errors were numerous. Whether Colorado's law applies to a given speaker undeniably turns on what he intends to say. A speaker wishing to approach another for the purpose of communicating any message except one of protest, education, or counseling may do so without first securing the other's consent. Nevertheless, the court deemed the law content neutral on the theory that it does not prohibit a particular viewpoint or a particular subject matter. But this court had never, and since Hill has never, taken such a narrow view of content-based speech restrictions. Buffer zones like the one at issue in Hill are obviously and undeniably content-based. Which brings us to the idea of content-based discrimination. See, it's one thing to establish rules for conduct in public that are content-neutral. The use of bullhorns or demonstrations that obstruct traffic, for example. But that is not what the Colorado law did. Rather, it determined that if the content was oral protest, education, or counseling, and if the content was expressed outside of a healthcare facility, that speech was restricted. Justice Scalia could identify only one explanation for the majority's anomalous decision. The jurisprudence of this court has a way of changing when abortion is involved. Hill reflects the ad hoc nullification machine that this court sets in motion to push aside whatever doctrines happen to stand in the way of abortion. Yes, this was content-based restriction of free speech. If the content was pro-abortion, no problem. But if it was anti-abortion, Colorado wanted to censor it, at least outside healthcare facilities, which was generally used as a euphemism for abortion clinics. As Justice Thomas noted, at the court, things change when abortion is in the mix. What we have here is another case of courts placing their opinions above the supreme law of the land. The court has received a number of invitations to make clear that Hill lacks continuing force. Some of those invitations have arisen in cases with thorny preliminary issues or other obstacles to our review. But no such obstacles are present here. It is undisputed that Carbondale's ordinance is identical to Colorado's law in all material respects. It is likewise undisputed that both the District Court and the Seventh Circuit dismissed Coalition Life's suit exclusively on the grounds that those courts felt bound by Hill. This case would have allowed us to provide needed clarity to lower courts. I guess I'd call that a swing and a miss. Once again, the court had a chance to fix a mistake from a previous court and didn't. In Dobbs, they fixed their decision in Roe, but here, they failed to fix their mistake in Hill. Hill has been seriously undermined, if not completely eroded, and our refusal to provide clarity is an abdication of our judicial duty. We are responsible for the confusion among the lower courts, and it is our job to fix it. I would have taken the opportunity to explicitly overrule Hill. For now, we leave the lower courts to sort out what, if anything, is left of Hill's reasoning, all while constitutional rights hang in the balance. I respectfully dissent. Yes, the Supreme Court has failed to provide clarity in regard to their previous decision, but the fault is not all theirs. After all, the judges of the district and circuit courts take oaths to support and defend the Constitution of the United States, not the opinions of other judges. If either of those courts, in this case, had bothered to look beyond precedent, they may have seen the 14th Amendment violation. Since our law schools apparently do not teach the Constitution, placing precedent as their primary concern, it's not really a surprise that the product of their education is so flawed. Perhaps one day we'll find someone who will bring a truly constitutional argument to a case like this. Who knows? Maybe such a well-founded argument could even turn the heads of the justices of the Supreme Court. We can always hope and work toward that day. What a tangled web we weave when first we practice to protect abortion. That's what the court's doing. Anywhere time abortion comes close, almost any time, well, they do all sorts of verbal gymnastics and legal limbos to try and protect it. And here's a classic example. Heal was bad law when it was decided in 2000, and it's still bad law today. And the fact that courts still follow it just shows how corrupt our judicial system at the federal level has become. I don't mean corrupt as in judges taking bribes under the table. You have a law that blatantly violates the Constitution of the United States, especially if you erroneously believe that the First Amendment applies to cities and states as well. But you cannot take the case to actually say that, to take your mistake from 2000 and fix it. I'd have thought after the Dobbs decision, the court would have shown more backbone, more chutzpah, more honesty. Apparently not. The Justice Alito did say that he would have taken the case. Only Justice Thomas took the time to write a dissent and point out the corruption of the Supreme Court. They've made this mess, and they've once again refused to fix it. And the courts, because they follow precedent rather than law, well, they just go along for the ride. Shows that we need people in the courts that actually have the spine to do the just thing. And we're not going to get that until we hire better people, both at the presidency and in the Senate, to confirm better justices. Even that's going to take time. Now, if you want to find the written article with all of the links to all my sources, we'll go to constitutionstudy.com and find out more. If you'd like to ask a question, go to constitutionstudy.com/questions and ask. I love answering questions. And if you want me to answer them on the radio program, there's a checkbox for that as well. But mostly, if you want to learn more, I have a couple suggestions. Obviously, you could read my book, The Constitution Study. Find it at constitutionstudy.com/shop. It's my personal clause-by-clause study of the Declaration of Independence and the Constitution, written in plain conversational English. It is a great start. You could also check out The Miracle of America. Interesting course I found. It pretty much takes history from the Pilgrims through the drafting of the Constitution. It helps explain why the Declaration is the way it is, why the Constitution and the United States government are constructed the way they are. I like the course so much, I made a deal with the owner to get you one lesson free so you can give it a try first. Just go to constitutionstudy.com/1776 study guide and check it out. All the information about the course is just a custom landing page just for my listeners. You can read up about the course, but most importantly, you can enroll for that free lesson on God's natural law. Get the downloadable study guide, get an hour of video or an hour of audio, whichever you prefer, absolutely free. So don't forget, check it out, constitutionstudy.com/1776 study guide to enroll in your free course. If you like and would like to take the whole course, well, that's just $17.76. Now, if you'd like to use your cell phone to help protect your rights, Patriot Mobile is America's only Christian conservative wireless provider. They give great service on the same towers and networks that the major carriers do, but they take a portion of their proceeds and they donate it to organizations that are defending your rights. Folds of Honor, Turning Point USA, and yes, even the Constitution Study. Go to patriotmobile.com/constitution and find a plan that works for you. I've been very happy with their service and with their prices. But if you use the code Constitution at checkout, you'll also get free activation. So again, head to patriotmobile.com/constitution to find a plan that works for you, and don't forget to use the code Constitution at checkout for free activation. I hope you'll just support the work that we're doing here. Go to constitutionstudy.com/shop, maybe purchase a book or a mug or a t-shirt, or just donate to the cause. A one-time or monthly donation would be very helpful to keeping all the lights on. But the greatest thing you can do is to share this information. To take the links to this article or the video, share it with friends, family, social media, wherever. And then invite some friends to come join you the next time we get together here at the Constitution Study.